Let's try this. Good morning, everyone. The meeting is called to order. Mr. Tobin, has anyone signed up for public comment?
Yes, good morning, commissioners. I believe we have Heather Torres to provide comment. Ms. Torres, if you're here, if you could unmute yourself, unmute your phone, and then state your name and who you represent, then go ahead with your comments.
Can you hear me? Sorry.
Good morning.
Hello, there's a lot of feedback. Oh, that's better. Okay. No, with me or not. It's just so loud. Okay. Well, thank you for having me. Sorry, every time I talk, there's so much background noise. I'm not sure what to do.
Chairman, I can hear her. I also hear the background noise, but I am able to hear comments.
Okay, so I could just start talking?
Yes.
Okay, thank you. My name is Heather Torres, and I am the Executive Director of Hope Lutheran Learning Center. I have been in the early childhood education, aka childcare, for 17 years. Starting off as a teacher's assistant and working my way up to Executive Director, a position I have held now for the past 11 years. I'm an active member of NACCE. Okay, what do you need me to do?
Can,
Are you there, Heather?
I can still hear you. I just can't see anybody.
I thought I put
Okay.
I just logging on as well. You're good.
Okay. Okay. I have been an active member and speaker for the NACCE and for the Association of Early Learning Leaders. Childcare centers and childcare teachers and employees are often overlooked and underappreciated in the field of education. At times, we are labeled babysitters and not real educators. We are often left out of Teacher Appreciation Week freebies and left off special thank you lists. If any of you have ever been in the process of purchasing a house and walked the floors of a potential home purchase, you would have noticed the paint colors, the windows, the floor layout. Rarely upon first laying eyes upon the house would you comment on the foundation is built upon. It will be overlooked until much further inspections are made. Early childhood education is the foundation in which a child's education, self-worth, and emotional and social intelligence is built upon. And at first glance, it is often overlooked. But sadly, my fellow early educators and I are used to this. During a time that is considered too dangerous for public schools to be open, child care centers not only remained open, but took in the very children not allowed to attend public school. In March, when child care centers were labeled essential, the early educators community rejoiced because finally we had been seen. The state of Texas was correct by allowing us to still operate because if we were closed, who would care for the doctors, nurses, electricians, and elected officials' children? Yes, we were given stricter guidelines, but this is nothing new for us. Then it was announced that the Texas Workforce Commission would cover the child care costs for essential workers. I passed this information along to the families that I serve because at the time we are only allowed to serve essential workers. Because it was not clearly stated, I had to investigate how much my center would be reimbursed by the state, and if I could charge the parents the tuition difference. After many phone calls and emails gone unanswered, I found out that the Texas Workforce Commission would only be paying the much lower state rate of child care tuition, and I was not allowed to charge the parents the tuition difference. These essential worker parents who are still receiving their full paychecks were not allowed to pay the difference of $35 per week. This meant that I had to provide the same service but at a 30% lower income. During a time where our cleaning and food costs are rising, I had to cut costs somewhere. Does this mean that I would have to cut the hourly rate of my essential employees, the actual teachers taking care of the children? This put my entire program at risk, along with other centers across the state. When I asked why we were not allowed to ask the parents to pay the difference and explained how by helping others you were hurting us, I was told that the Texas Workforce Commission had not thought of this aspect before, that the Texas Workforce Commission, you are human and you make mistakes, and that it is that the essential parents that I'm serving risk their lives by working, so they deserve this break. I assure you that childcare providers are risking our lives more than a parent who is working from home. We cannot social distance from a 2-year-old who is having a bad day and needs more hugs. I urge all of you, before you pass any more bills, laws, or grants, to consult actual childcare directors that are currently on the front line of this pandemic. Ratios, cleaning, and any other new rules that will be passed will directly affect thousands of people's lives. I would be more than happy to be contacted in the future to advise the Texas Workforce Commission in any way I can. Please allow us to pass the tuition difference to the parents, as giving them a 70% discount is still a great way to say thank you and allows us to operate fully funded. When can we start charging the parents a difference? And another concern is, when can we start caring for non-essential parent children? That is all.
Thank you. All right, are there any other public comment? All right, hearing none, let's move to agenda. Good morning, Ms. Miller.
Good morning, sir.
Let's see, I'm showing under agenda item 3, we have no case to reconsider, is that correct?
That is correct. No cases under agenda item 3.
We have no tax cases under agenda item 4 on docket 19, is that correct?
Yes, sir, that is correct.
All right, see, we have no fair housing cases under agenda item 5, is that correct?
Yes, sir, that's correct.
We will now move to agenda item 6. We have no wage discussion on docket 19, is that correct?
Yes, sir. There are no cases pulled for additional discussion. You should already have received the short form dissent list for the wage claim cases on docket 19.
I'll move to staff recommendation for remaining cases on docket 19.
I second the motion except for those cases on which I am dissenting as reflected on the wage claim short form dissent list for docket 19.
Chairman's motion, except for the cases on which I'm dissenting, is reflected in the wage claim short form dissent list for docket 19.
The motion passes with the exceptions noted.
Thank you, sir.
Let's move then to agenda item 7, consideration of unemployment insurance on docket 19. Please proceed when you're ready.
The first case is case number 2457013. Commissioner Alvarez?
The AT decision is not supportable. Because the claimant did not receive the AT1 decision, his petition to reopen should be deemed timely. The claimant missed the first hearing because he called the hearing officer's direct number to register for the hearing prior to the hearing's start time. The claimant then called the 800 number to register for the hearing just a few minutes after the hearing's start time. Therefore, the claimant made a good faith effort to participate in the first hearing. The claimant's petition to reopen is timely. The claimant had good cause for his non-appearance. Resubmit for merits.
The AT decision should be affirmed. I agree that the claimant filed a timely Rule 16 petition to reopen. Regarding good cause, misreading of the hearing notice instructions was within his power to control. Therefore, he did not establish good cause for his non. As to the merits, the available record indicates that the claimant separated from employment when he was absent after his car broke down while he was out of town. Requested leave of absence as required, and he had received warnings for absenteeism. Therefore, regardless of whether we view this case as a quit or a discharge, the disqualification is appropriate since the claimant did not take adequate steps to protect his job and since his unapproved absences were due to personal reasons. We should affirm the AT decision. Timely Rule 16. The claimant did not have good cause for his non-appearance, voluntary leaving, and no chargeback.
Modify the AT, timely petition reopen, claimant establish good cause for AT1, resubmit.
Thank you. We will resubmit the case. Next case is case number 2461337. Commissioner Alvarez?
The decision should be modified. The claimant's son was born on 2/1/19 and was in the NCIC, the NICU unit. The employer insisted that the claimant return to work in early March 2018. It appears that the claimant was eligible for FMLA. The employer did not dispute that the claimant was eligible for FMLA, but there is no evidence that the employer complied with its obligation under federal law to begin the FMLA process when it became aware that the qualifying event had occurred. Because the employer failed to comply with its obligations, the claimant had good cause. The claimant had to quit to be with his son in the NICU. Modify the AT, no voluntary leaving, no chargeback, MVI, minor child.
The AT decision should be affirmed. The claimant quit a reasonable reprimand and because he was upset that the employer was contacting him to come into work. Neither of those reasons connected with the work for quitting. There is no evidence that the claimant report to work was unreasonable or outside the parameters of the claimant's hiring agreement. The claimant also quit immediately without pursuing reasonable alternatives, such as addressing his concerns with HR or requesting a leave of absence. Moreover, I would not agree to an MVI in this case. Not only was reasonable alternative care available for the claimant's child, but the medical documentation and the evidence shows that the claimant's child had been discharged from the neonatal intensive care unit the month before the claimant resigned. Since the claimant made no attempt to protect his job or provide the employer with an opportunity to address his concerns, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Long form dissent.
Thank you. I have a long form dissent for Commissioner Alvarez. The next case is case number 2462326. Commissioner Demerson?
The AT decision on good cause should be reversed. The employer missed the hearing because he was grieving the recent death of a close friend. It is unreasonable to expect a party to appear for a hearing during a time in which he is processing an emotional. Thus, the employer had good cause for his non-appearance, and the case should be resubmitted for additional merits testimony. In the alternative, if my fellow commissioners do not agree that the employer established good cause, the current record supports a reversal on the job separation. The employer provided credible, detailed first-hand testimony regarding final incident. That testimony should hold more weight over the claimant's sworn denial because the claimant's testimony is contradicted by emails and text messages he sent to the employer and other co-workers. Accordingly, I would also agree to modify the decision, no good cause for the employer, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. The employer's president testified that he forgot about the hearing. He also stated that if he had not forgotten, he would have participated. As such, the employer did not establish good cause for their non-appearance. Regarding the job separation, the parties provided conflicting testimony. The AT's position that both parties had equal credibility is supportable. Therefore, since both parties presented one first-hand witness, the employer failed to establish misconduct by the preponderance of the evidence. Affirm the AT, no employer good cause, no misconduct, chargeback.
Modify the AT. Employer did not establish for AT1. Misconduct, no chargeback, adequate response.
Short form dissent.
I have a short form dissent for Commissioner Alvarez. Thank you. And the next case is case number 2463522. Commissioner Alvarez?
Do we have another what?
I'm afraid someone needs to mute their microphone. The fourth case is case number 2463522. Commissioner Alvarez?
The AT should be reversed. The claimant returned to work during the benefit week ending September 7, 2019. On September 9, 2019, the claimant notified the commission that he had returned to work. When the claimant provided notice that he had returned to work, he was told that he did not need to do anything other than request his final payment, even though there was an outstanding request for a work search log. Under Appeal 2722-CA-77, a claimant with a return to work date within 6 weeks is no longer required to search for work. The claimant should not be held ineligible for failing to produce a work search log for the benefit week, during which he was not required to search for work. The claimant's appeal should be deemed timely, and the reporting and overpayment should be voided. Reverse the AT deemed appeal timely, void reporting and overpayment determinations.
We should affirm the appeal tribunal decision. The request for a work search log was sent to the claimant before he filed his last payment request. While still in pay status, the claimant should have been checking his mail and responding to TWC requests. Because the claimant did not establish any exceptions to the timeliness rule and simply failed to check his TWC inbox, the claimant appeal was not timely, and we do not have jurisdiction to consider the underlying merits. We should affirm the AT decision. The claimant filed a late appeal, reporting not eligible August 18, 2019 through August 24, 2019, overpayment of $507.
Reverse the AT, timely claimant appeal, reporting and overpayment from inception.
All right, I have a majority vote, timely claimant appeal, void the reporting and overpayment determinations.
Sure. Chair, I'm going to short form dissent on that.
Thank you. I have a short form dissent with Commissioner Demerson. Next case, case number 2463795. Commissioner Demerson?
We should reverse the appeal tribunal decision. I agree that the timely appeal to the determination. As to the timeliness of protest, TWC records indicate that the notice of claim was returned to the agency because it was mailed to an incorrect address. The employer has provided credible evidence that it had previously updated its address with TWC. Accordingly, because the employer did not receive the notice of claim, we should reverse the AT decision. The employer filed a timely appeal. The employer filed a timely protest to the notice of claim. Resubmit the case for merits testimony.
The decision should be modified. The employer updated their address during the appeal period. Therefore, the employer filed a timely appeal. Regarding the timeliness of the employer's protest, the employer failed to timely update their address with TWC. Even if the employer updated their address for a related entity, it doesn't change the outcome in this case, as the notice was mailed to the employer's correct address of record, and the employer failed to respond by the deadline. The employer did not file a timely protest. Modify the AT timely employer appeal, no timely protest.
Reverse the AT, timely employer appeal, timely protest, resubmit.
Thank you. I have a majority vote to timely appeal, timely protest, and resubmit. The sixth case today is case number 2471851. Commissioner Alvarez?
The claimant's appeal should be deemed timely. The claimant requested his medical provider fax in medical documents to the commission on his behalf on October 31st, 2019. This was within the appeal timeframe for the October 21st, 2019 determination. Therefore, the fax medical documents on this October 31st should constitute a timely appeal from the claimant. We should deem the claimant's appeal timely and resubmit for merits testimony.
We should affirm the appeal tribunal decision. The claimant's confusion does not constitute an exception to the timeliness rules. Because the claimant's appeal is not timely, we do not have jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision. The claimant filed a late appeal, voluntary leaving, no chargeback.
Commissioners, I'm informed by general counsel that our meeting is not actually public right now due to some technical malfunction. I'm going to ask us to pause right here and take no further action. I'll apologize in advance. I'm going to ask you to restate the vote when we come back on pull number 6. So if we'll stand down for just a minute, we'll try to resolve this technical.
Congrats to him and Judy.
Right.
Both come in and congrats his father on and all. And then because I said congrats both, I said that's
here, because we're gonna miss live.
And we set up a meeting with them.
Yeah, it's easy, it's blank and it's recorded.
Yeah, she said,
Which, this kind of blank. I'm supposed to see this. Yeah, I am there. Yeah, but I know that it's working when I can see it here. The rest, Fran is supposed to see it.
they're online. You have a response?
And just put the number or something. Okay. Yep. Yeah.
You want me to get a Sam's number to call?
Sam's out today, so I didn't know what the other guy. Let me call, Tom, do you want me to call Francis? Cause it's not. And just let them log in and listen, right? Because it's gonna be too, I think it's gonna be difficult for them to fix it right away. Give a call, so let me get off the phone with you, Tom, and then call them real quick and see. Okay. Okay, well, I mean, everything is still going as it should, and then so you have to log in, it'll go live again. Okay, bye.
So right now, it's just not me recording of this meeting?
It's recorded, I'm recording it.
Oh,
It's
okay.
just outside people can't see from the Granicus link, that's the only thing that's not working. Yeah, I think this thing is not very, doesn't seem to be very reliable.
But do they not just run that constant?
No, this is the first time that it's not working, but, I'm trying to fix it real quick. Like, we can't download, we can't hyperdrive anywhere, like, we get our watch, we get our. Hey guys, it's Julia Mercado with PwC. Is this something that could be fixed quickly, or is it something that is gonna take a while? You know? Okay. No, we're in the middle of the meeting, and I was just told that it wasn't working, because it works in the room that I'm in. Cause I know it's not working if I can't see it, but I can see it just fine on the screens that's in the room. And the encoder is supposed to pick up that feed and, you know, the live stream of it. And so it's working on my end, it's the encoder it's not picking up the stream. And we paused the meeting, I just don't know whether or not we're supposed to wait, or I just need to know so we can move forward.
Let me get on the system.
Yes. Okay, thank you, Chris. Thanks, bye. No, it's okay, it shouldn't take you long.
Okay. I'm showing that we're on case 2471851.
That is correct, sir.
Okay, Ms. Miller, if it's all the same to you, let's back up and have Commissioner Alvarez state his vote again, same for Commissioner Demerson, and they've both given their rationale. I think that'll catch us back up in an appropriate way.
Yes, sir. Case number 2471851, Commissioner Alvarez.
When I do the access code, you enter your attendee number.
Commissioner Alvarez?
I'm showing that Commissioner Alvarez has dropped off. So let's hit pause for just a second. Sorry. and we'll see if we can find Commissioner Alvarez.
Thank you.
It's not showing me. And I just logged in.
I'm hearing you.
Yeah, I don't see, can you hear me?
I can hear you, but I can't see you.
I know I can't see myself either, which is okay. But I can hear you guys a lot better, that's important, so.
That being
The cameras,
the screen,
there's no icon there for the screen like I generally have. I have the mic. I don't have one. Yeah, usually-
all right, Commissioners, I'm gonna pause again for troubleshooting to see if we can figure out where, there's your video feed, Commissioner Alvarez.
Got it. Now it's coming up.
Yeah,
Perfect.
there you are.
Awesome. Sorry for the inconvenience. Chairman, you want me to go back on that? Never mind, Chairman. Go on. Proceed.
Then I'll start over with case number 2471851. Commissioner Alvarez.
The claimant's appeal should be deemed timely. The claimant requested his medical provider fax in medical documents to the commission on his behalf on October 31st of 2019. This was within the appeal timeframe for October 21st, 2019 determination. Therefore, the fax medical documents on this October 31st should constitute a timely appeal from the claimant. We should deem the claimant's appeal timely and resubmit for merits testimony.
Sherry, just for clarity, I'll go ahead and read as well. We should affirm the appeal tribunal decision. The claimant's confusion does not constitute an exception to the timeliness rules. Because the claimant's appeal is not timely, we do not have jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision. The claimant filed the late appeal, voluntary leaving, no charge back.
Affirm the AT, untimely claimant appeal, voluntary leaving, no charge back.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. Moving on to case number 7. It's case number 2473979. Commissioner Alvarez?
I'd reverse the AT decision. The claimant left his job working out of town for the employer in order to return home and take custody of his minor child after being notified that CPS had removed his son from his mother's home based on an allegation that the mother was abusing the child. The claimant has joint custody of the child and had no other choice but to take leave from his job in order to handle the urgent and compelling matter involving his minor child. Reverse the AT, not disqualified, urgent, compelling, and necessary.
We should affirm the appeal tribunal decision. I sympathize with the claimant's situation and can appreciate his decision to leave work to attend to an important family matter. However, the claimant quit his job while work was still available for a personal reason, not for good cause connected with the work. Therefore, we should affirm the AT decision of voluntary leaving.
Affirm the AT, voluntary leaving.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. Next case, case number 2475828. Commissioner Demerson.
The commission should grant a rehearing in this case. The claimant was discharged for failure to complete his bag checking duties. The employer has offered to share video evidence of the final incident. Since the video would provide visual evidence of the claimant's bag checking activity, we should hold a rehearing for the employer's video evidence.
The decision should be affirmed. The employer alleged that the claimant was not properly checking bags. However, they failed to provide any first-hand witnesses and failed to provide any evidence that the claimant had been trained or instructed to check bags in a particular way. The employer's witnesses were not involved in the claimant's discharge. The claimant, on the other hand, provided credible first-hand testimony that he conducted the bag checks in accordance with the training and instructions he received. Therefore, the employer has not shown misconduct. Affirm the AT, no misconduct charges.
Rehear to obtain video evidence.
Thank you. We will rehear the case. Next case is case number 2476161. Commissioner Demerson?
The appeal tribunal decision should be reversed. The claimant was discharged for processing excessive amounts of refunds. The employer provided sworn testimony that the claimant was trained in refunds. Since the claimant did not show up for the hearing, her fact-finding statement to the contrary should be given less weight. The employer also testified that the claimant was instructed to staple the original receipt to the refund orders, but there was no receipts available for her refunds. Claimant's mismanagement of the refund process cost the employer hundreds of dollars over a 2-month period and constituted misconduct connected with the work. We should therefore reverse the AT decision, misconduct, no charge back, adequate employer response.
The decision should be affirmed. The employer testified that the claimant was discharged for having higher than average refunds. However, the employer did not present evidence of a policy that the claimant violated. Additionally, about half of the refunds would be higher than average. Therefore, this would not be a good basis for disciplinary action. The employer failed to warn the claimant about how she was processing refunds without evidence that the claimant was violating a known policy. The employer has not shown misconduct. Affirm the 18 no misconduct charge.
Reverse the 18, misconduct, no chargeback, adequate response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. Next case is case number 2478056. Commissioner Alvarez?
The AT decision should be reversed. The claimant eventually quit after the employer continued to short her on her paychecks. This had been an ongoing issue for months, and the employer was frequently either shortening the claimant on her pay or arguing with the claimant about paying her for all the hours she actually worked each week. The claimant complained multiple times to the employer, yet the problems with her pay continued. The claimant finally quit after her pay was, again, short for her final 2 weeks. Therefore, the claimant had good cause to quit. Reverse the AT, no voluntary leaving charge.
The AT decision should be affirmed. Since the claimant resigned before giving the employer an adequate opportunity to address her concerns, she did not establish good cause connected with the work for quitting. We should affirm the AT decision, voluntary leaving, and no chargeback.
Reverse the 18, no voluntary leaving, chargeback.
Short form.
Thank you. I have a short form dissent for Commissioner Demerson. Next case is case number 2478600. Commissioner Alvarez?
The decision should be reversed. The employer presented only hearsay testimony to support its allegations. The district manager who testified before the AT did not conduct the investigation and did not interview the claimant regarding the allegations. The claimant denied under oath that he was aware that his purchases were improperly discounted. The claimant shopped an outlet location and not his own retail location. The employer has not provided any documentary evidence to show that the claimant was responsible for transferring the merchandise to the outlet or setting the price. The claimant's sworn denial of wrongdoing carries greater weight than the employer's hearsay. The employer failed to carry its burden of proving misconduct. Reverse the AT, no misconduct chargeback.
The appeal tribunal decision should be affirmed. The claimant was discharged for activities surrounding the receipt of unauthorized discounts. The employer testified that the claimant admitted knowing that the discounts he received of approximately 90% were unauthorized. The employer also testified its investigation revealed the unauthorized discount activity was coordinated and resulted in the termination of 9 employees. As such, the claimant's actions constituted work-connected misconduct. We should therefore affirm the AT decision, misconduct, no chargeback.
Affirm the 18, misconduct, no chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. The next case is case number 2480269. Commissioner Alvarez?
The AT decision should be modified. The claimant went out on a medical leave on November 2nd. She then returned to work. She then returned to her job on November 27th. While the claimant was working, the manager on duty noticed that she still appeared to be sick. So, the manager sent her home because it was unsafe for the claimant to work around food in the employer's restaurant. The manager also advised the claimant that she could not return until she had a doctor's release. The claimant was then taken off the schedule for the next few weeks. Therefore, the claimant continued claim separation occurred when she was sent home, and then removed from the schedule due to the employer deeming her too sick to work around food. Such a separation is a discharge for reasons other than misconduct. Modify the AT, no misconduct. MVI, claimant not able to work 11/24/19 through 12/7/19, recalculate the overpayment.
The appeal tribunal affirmed the employer's testimony reveals that after being released back to work, the claimant did not show up for her assigned schedule. As such, the claimant voluntarily quit her job. The record supports affirming that issue. We should therefore affirm the decision, voluntary leaving, claimant not able to work from November 24th, 2019, December 7th, 2019, overpayment.
Modify the AT, no misconduct. Claimant not able to work November 24, 2019 through December 7, 2019. Recalculate the overpayment.
Commissioner Demerson, did you want to defend?
Yeah, I'm in a short form.
Thank you.
Short form of the job separation.
Thank you. I have a short form dissent for Commissioner Demerson on the job separation.
Thank you.
Next case is case number 2482790. Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant was discharged after the allegations of abuse against a resident were confirmed by a comprehensive agency investigation. Not surprisingly, the claimant denied the allegation. However, the employer provided a copy of the investigative report, which included multiple witness statements and a description of the video of the final incident. This evidence was more than enough to overcome the claimant's denial. Accordingly, because the preponderance of the evidence established that the claimant physically abused a resident by spraying water in her face as corporal punishment, the claimant was discharged for misconduct connected with the work. We should reverse the AT decision, misconduct, reimbursing employer not billed, adequate.
Ms. Miller, can I ask what the desired result was for Commissioner Demerson? I could not hear it.
Commissioner Demerson, could you please repeat your vote?
We should reverse the AT decision, misconduct, reimbursing employer not billed, adequate employer response.
Thank you. The decision should be affirmed. The claimant provided firsthand testimony that she did not abuse the patient and was only offering the patient water to wash her hands. The employer chose not to present any firsthand testimony. As such, the employer has not shown misconduct. Affirm the AT, no misconduct, bill reimbursing employer.
Reverse the AT, misconduct, reimbursing employer not billed, adequate employer response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. And the last case pulled for discussion on today's docket, case number 2483101. Commissioner Alvarez.
The AT decision on the separation issue should be reversed. The claimant is an older employee with health problems who needed help performing certain job duties due to his physical limitations. When he asked the store manager for help, the store manager basically told him to quit or be fired. The evidence also indicated that the employer refused to allow the claimant to use disabled parking spots that he was legally entitled to. The general manager's unreasonable and inappropriate response to the claimant's request for reasonable accommodations gave the claimant good cause connected with the work to resign. Modify the AT, no voluntary leaving, chargeback, sever ruling on alternate base period.
The appeal tribunal decision should be modified. I agree that the alternate base period issue should be severed. As to the job separation, the preponderance of the evidence establishes that the claimant did not afford the employer an adequate opportunity to remedy his concerns. We should therefore modify the AT decision, voluntary no chargeback, sever the alternate base period issue.
Modify NET, voluntary leaving, no chargeback, sever the alternate base period issue.
Short form dissent?
And I have a short form dissent for Commissioner Alvarez. Thank you. That was the last pulled case. You should already have received the UI short form dissent list for docket 19.
I move we accept staff recommendations on the remaining UI cases on docket 19.
I second the motion except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 19.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 19.
The motion passes with the exceptions noted.
Thank you, sir.
Thank you. This brings us to the end of agenda items 1 through 7. Let's then move to agenda item 8. Discussion, consider possible action regarding an order to adopt program year 2020 and fiscal year 2020 allocations, planning estimates, and funding distributions to local workforce development areas.
It should be Chris, but I don't. Chris Nelson, are you on the? Mr. Chairman, we may go on to the, if I can impose upon you on the next agenda item, and I'll see where Chris is at.
Say that again, Mr. Serna.
If I can impose upon you to go on to the next agenda item, the COVID-19.
You sure can.
I'll see where Chris Nelson is at.
Understood. Thank you. So we don't need agenda item 9. We'll go ahead and take up agenda item 10 while we're solving the technical difficulty on Chris. This is discussion, consideration, and possible action guidance on resource utilization and implementation of services and strategies. Target disaster relief efforts and public health emergencies, including those funded with the disaster dislocated worker grant.
And before Clay gets started, I was going to just ask everybody that's on the call, whether they're a TWC employee or otherwise, to just mute your phones, your laptops, whatever, because I'm seeing a lot of other people call in user 88, 87, 63. We're hearing background noise. Okay, is he ready? I think Chris Nelson is ready. He got knocked off the call. So, Mr. Chairman, if we could go back to that agenda item, I'd appreciate it.
All right, we're back to agenda item 8, as stated previously.
Good morning, Chairman, Commissioners, Mr. Serna. For the record, Chris Nelson, Chief Financial Officer. Can you hear me?
We can hear you.
Okay. This morning you have before you the FY21, PY 2020 allocations for WIOA, adult, youth, and dislocated worker, rapid response distributions, and adult education and literacy planning estimates. These would go into contracts effective July 1st, 2020. Page 1 of your document is a summary of the adult, youth, and dislocated worker total allocations. Pages 2 through 4 are the individual allocations by local area for each program. A few things to note, these amounts reflect an overall 7.5% reduction to the WIOA allotments, mainly coming from reductions to the Texas allotment of adult and youth funding. Texas's the dislocated worker funding also received a slight reduction, but much smaller than the adult and youth funding. The allocation of these amounts reflect factor data from 2019 as the economy was doing very well in Texas. And two of the factors used, about 66% of the adult and youth allocations, show reduced counties in areas of substantial unemployment and reduced numbers of excess unemployment in areas of substantial unemployment. This accounts for the increases and decreases by local area for adult and youth, along with the reduced state allotment. On page 5, you have the rapid response distribution, which represents 1.25% of the dislocated worker allotment, consistent with what we did last year. Starting on page 6, you have the planning estimates for adult ed. We should be receiving the final allotment in the next few weeks, at which point we'll bring the final document to you for approval for the final allocation. For AEL, the planning estimate allotment is 1.2% higher than last year, so slightly more than we got compared to what just happened on WIOA. And that concludes my remarks. I'd be happy to answer any questions.
Questions or comments?
No questions, Chairman, here.
None here.
Thank you. Do we have a motion?
Yes, Chairman. I move that we approve fiscal year 2020 block grant allocations, distributions, and planning estimates for WIOA adult, youth, and dislocated worker, rapid response, and AEL as discussed by staff, and order the executive director to administer these block grant allocations in the most feasible and economic manner within all guidelines prescribed by HB1, General Appropriations Act, 86 Legislature, regular session, the Texas Labor Code, and TWC rules.
Second.
It's been moved and seconded. We're unanimous. Thank you.
Thank you.
Let's move back to agenda item 10, as previously stated.
We'll have Clay Cole first and then Courtney Arbor.
Okay, good morning, Commissioner Daniel.
Good morning.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson. Mr. For the record, Clay Cole Unemployment Insurance. UI has experienced a downturn in UI claims over the past week. However, levels are still much higher than the pre-COVID-19 days. UI and IT teams deployed the Pandemic Emergency Unemployment Compensation Program over the weekend. Payments for PEUC starting yesterday. Over the next couple of weeks, TWC will be mailing approximately 130,000 notices to potential customers, providing instructions for applying for the 13-week extension of federal benefits for those individuals who have exhausted regular state unemployment benefits dating back to 2019 in some cases. The process can be very simple, as individuals are calling an IVR and answering a couple questions, which can trigger the claim unless there's an issue that we detect up front. Teams have deployed assembly line processing plans for processing the Pandemic Unemployment Assistance Proof, the PUA-DUA proof. Processing began accelerating last week with the addition of new temporary staff, and today UI staff will be training TWC facility staff on helping processing DUA, PUA, federal income tax proof, and other employer responses. TWC partner call centers are learning new skills, enabling them to service a greater number of UI customers and assist with outbound calls. This will continue to help TW experienced staff focus on highly skilled assignments. UI continues to work closely with communication, finance, operational insights on messaging outreach and data analytics for reducing and preventing unnecessary calls to call centers. This week we'll be drilling down into some additional trends and efforts to identify claims that can be updated with automated scripts. UI continues to actively work on plans for Texas opening back up for business. UI and IT deployed a new website portal this weekend to capture information from employers about individuals not able to return to work. UI continues to monitor assignment productivity closely for training and shifting internal resources to areas of most pressing need. And again, just a big thanks to all our TWC volunteers for helping us during these unprecedented times. This concludes my update, and I'll be happy to answer any questions you may have.
Thank you. Questions or comments?
None from here, Chairman. Thank you. Scott Floyd.
No questions here. Thank you.
Thank you. Thank you, Clay.
Courtney Arbor.
Good morning, Commissioner. Mr. Cerna. For the record, Courtney Arbor, Workforce Division. On April 14th, the Commission took action to make funds from several state federal funding sources available for COVID response. Much collaborative activity has taken place from that time to now to develop and execute grants between workforce, business operations, legal, and finance, and others. Have acted quickly to bring those activities into play. Staff were asked at the April 14th Commission meeting to share a one-month update on the status of those funds, and my remarks today will provide that update. Commission vote, grants were executed to the 28 workforce boards, making TANF funds available for purchasing tools to assist employers and job seekers remotely, for remote hiring events and other online services, in addition to hiring staff and expanding their online presence through website activities. Procurements and purchases are underway for distance learning and website expansion, and updates have been made to their websites. And the hiring of staff is also underway in the 28 board areas. Funds were approved for adult education and literacy activity for distance learning through purchase of software and other online tools, enabling greater reach for student instruction. And approximately $1 million in expenses at the local level are already contracted in development. Commissioners, you're aware that the funds were also made available for integration staff at the site, the AEL sites, doing follow-up with students to determine testing and employment outcomes. Students now will include a discussion of any layoffs, including COVID-related layoffs, with referrals made to Workforce Solutions offices for help. So the timing of those funding, that funding, and the additional funding you provided is timely given our economic situation. 9 applications have been submitted, all approved, totaling just under $1.4 million. The funds will be used for training, in addition to purchasing software or expanded licenses for software for virtual hiring events for employers and employers with other layoff aversion and rapid response strategies, such as personal protective equipment, wage assistance, or other unplanned COVID-related costs, with training being a real priority here to help with layoff aversion or upskilling in this changing economy. Also, boards have purchased literature and materials to assist job seekers in transitioning to reemployment in this changing economy. On skills development, 9 applications have been received requesting training in sectors that are in highest demand right now, including manufacturing, hospitality, food chain supply, and including meat processing plants, healthcare, and transportation are the greatest priority. In future weeks, I'll provide you with information about the trainee counts. These applications are approved and underway, and we'll be able to tell you with these number of funding streams, updates on the number of people who have been impacted or receiving training services, specifically with the dollars. I'm happy to answer any questions you have.
Any comments or questions?
Chairman, the only comment I have is to just acknowledge the great work that Dale and his team, and of course Anson, have done to inform the folks around the state about the various opportunities they have for short-term training. So I just wanted to acknowledge that. So thank you.
Mr. Chair, I wanted to comment on the virtual hiring events that the boards are taking on. I think as we begin to reopen and talk about jobs that are available, those are vitally important. We were visiting with the site consultant about a few weeks ago, and making sure that we have one into those positions is very important for the employers here in Texas. And so I commend the team on what they're doing around that as we adjust to the situation we're dealing with.
Thank you. Courtney, thank you.
Thank you.
And Mr. Chairman, Commissioners, I have one item under this agenda item, and that is to inform the Commission that staff has started developing proposals to present to the Commission in formal meeting on when we will reinstate our work search. We've got some information that I'll be sharing with the Commission offices, and we'll make public, of course, that goes hand in hand with what Clay and Courtney have reported. Of course, Clay reported on our continuing UI activities. Courtney reported on our preliminary steps in the recovery and restart of the economy. And part of that is us looking at alternatives on when we will reinstate work search. We recognize, of course, that there are constraints still in the economy. We want to take those into consideration. I know that I was quoted in the Texas Tribune as indicating that when the governor established 50%, that we would go to 50%, and that may be something that we propose, but there are other alternatives as well that we would propose to make that may make more sense. So that's just kind of a starting stake in the ground that I challenge staff with, starting putting plans together. I have had conversations with legislative members and we'll continue to seek the input from our staff with regard to where the economy's at and the availability of jobs for the individuals as well. Plus, the exceptions that we have in place right now would continue to apply with regard to the impacts of COVID, quarantine, health issues, and of course, childcare. So this is just a heads-up item to let the commissioners know that staff will be proposing something in the next week or two on how we believe we should re-implement.
Well, that's an important next step for us, and I would encourage you and staff to continue to visit with the multiple stakeholders that are interested in this issue. There are a number of factors that we need to consider, and even some variables. An informed decision here, I think, is very, very important. And so whether the next meeting or the next, I look forward to having that information to help this commission make an informed decision. Commissioners, comments or questions for Mr. Cerna on this issue?
No, Chairman, but thank you, Ed, for providing us with an update and meeting with your staff regularly, and obviously with the governor's office regarding what our next steps will be. So thank you for that.
I have nothing else, Mr. Chairman.
Okay. Well, Commissioner Demerson, are you wanting?
No, I was just going to say a strategic and calculated approach, as you mentioned, is the way we want to go towards work search.
Absolutely. Thank you, sir. Mr. Turner, thank you. That's all we have in agenda item 10 is what I'm showing. Tom, do you have a report today?
Yes, sir. I do have a report. Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson. For the record, Tom McCarty, External Relations. Congress returned from recess last week. While there has been talk of further stimulus bills related to COVID-19, neither chamber has begun to move in any new pieces of legislation yet. We will, of course, keep your offices informed as things develop. We are monitoring one federal hearing this week. Today at 10 a.m., the U.S. Senate Health, Education, Labor, and Pensions Committee is holding a hearing titled COVID-19, Safely Getting Back to Work and Back to School. This concludes my remarks, and I'm happy to answer any questions you may have.
Thank you, Tom. Comments or questions? I'm hearing none. Thank you. Mr. Smith, do you have anything to report under the Executive Director report?
No, sir. Only that staff continues to concentrate, as Clay reported, on our support of our fellow Texans on the UI side, and Courtney and her team, and Megan and her team continue to provide support on the restart effort, and we'll continue to do that.
Yeah, I encourage staff to continue to work together as we look at ways to restart not just our offices, but certainly the services that we're providing to Texans. I think we're going to have to be somewhat creative in the way we provide services to people, and maybe even some novel and new services that we haven't thought of. Mr. Turner, I do encourage staff to work together across divisions. I know it's difficult when we're moving as rapidly as we are to sometimes consult with our colleagues, but I think that it's pretty critical here that we do that. I think our folks have been doing a great job at addressing issues as they come up. I see us moving toward hopefully a more proactive kind of approach and maybe anticipating some things. This happened very rapidly, responded very rapidly, and sometimes I feel like we had to feel our way to a solution rather than approach it directly, and I think that's understandable. That's not a criticism from me. It's just simply stating the facts of what we saw. But as I see businesses able to reopen under the protocols that the governor has announced and that the state's scientific and medical community are encouraging us to do, I think that employers are going to have some questions. I think that employees are going to have some questions. And I think that a number of answers to those questions are going to come from our staff here at TWC, both in an advisory capacity and then our ability to deliver programs. The short version of what I'm suggesting is that I continue to encourage staff to put these things in writing, bring them to the commission in writing and collaborate with their colleagues when they do it so that we have a fairly cohesive plan.
Yes, sir, absolutely, we will.
Any questions or comments for Mr. Cerna?
No, Chairman.
None here.
Is there any other order of business to come before the commission today? Hearing none, do we have a motion to adjourn?
Chairman, I move that we adjourn.
I second.
It's been moved and seconded to adjourn. We're adjourned. Thank you.